Hi, Gary. This is April. So I can see your video and it looks like your phone is connected as well. So when you're ready to speak, you'll just need to press *6 on the phone and you'll be good to go.
So you can hear me now?
Yes, that's great. I can hear you now.
Okay. I'll be quiet until the meeting, until it's my turn.
Okay, sounds good.
That's why these things. Turn it off.
Good morning. My name is Eric Blank, and this is the Commissioners' Weekly Meeting for February 25th, 2026. Commissioner Plant, any preliminary comments? Are you ready to approve the consent agenda as presented?
I would vote to approve the consent agenda. Good morning.
Morning, Commissioner Gilman.
Morning. I would also vote to approve the consent agenda.
As would I. 25A0476R BNSF Railway, Mr. Farrell.
Morning, Commissioners. Yes, Alan Farrell with Rail and Transit Safety Section, here to address any discussion on 25A-0476R and 25A-0497R. And if you're ready, I can proceed.
That'd be great.
Okay. On November 6, 2025 and November 24th, 2025, BNSF Railway Company filed two applications for orders authorizing replacement of the flashing lights, bells, gates, and bungalow, and to upgrade the track circuitry from motion detection to constant warning time at two separate crossings. One at the crossing of Richards Lake Road in Fort Collins, and the second at the crossing of County Road 21 in Fort Morgan, respectively. BNSF stated that the changes are necessary because the bungalow gates, bells, and flashing lights at both crossings are of an older variety, and BNSF no longer has spare equipment in the event of a failure. By decisions numbers C25-0949 and C26-0017, issued December 31st of 2025 and January 9th of 2026, respectively, the Commission deemed both applications complete and granted the applications. In the decisions, the Commission ordered BNSF to notify the Commission in writing when the work is complete, and to update the U.S. Department of Transportation crossing inventory forms for the crossings. The Commission stated that it expected these documents to be submitted by June 1st, 2026. On February 10th of 2025, BNSF made two filings titled Motion for Variance for an Extension of BNSF's Filing Deadlines for both proceedings. In these filings, BNSF states that budgetary considerations necessitate moving the dates of BNSF's work at the crossings to 2027. BNSF now anticipates starting the projects on January 1st of 2027 and completing the projects on June 1st of 2027. Accordingly, it requests the Commission grant an extension of the date to file the documents ordered by the Commission. And unless you have questions, I have a recommendation.
No, we'd welcome your recommendation.
Staff recommends the Commission grant the motions and require BNSF to comply with the requirements of decision numbers C25-0949 and C26-0017 by June 1st of 2027.
Commissioner Plant,
I agree.
Commissioner Gilman,
I also agree.
as do I, and that can be an ABC order granting both motions. So thank you, Mr. Farrell.
Thank you, Commissioners.
26AL-0055TR Ramlin Express, Mr. Bramlett.
Hi, Gary. This is April. You'll just have to press *6 on your phone again to speak. Sorry, I had to mute you earlier. So just *6 on your phone.
Can you hear me now?
There
Yeah.
you
I have a problem. I haven't used the phone because I didn't even know I had one. The microphone on the computer doesn't work anymore. So, which is tough for a guy like myself.
Speak loud. You're a little faint, but we can hear you now.
Okay. Hey, this is two revised pages to tariff filed by Ramblin on January 28th. Effective date is March 2nd. Ramblin Express may, under its certificate, provide scheduled service between Point in the metro counties and the casinos in Black Hawk and Central City. The first page raises the fares for the one-way and round trips from two zones in the metro area based on the mileage to Black Hawk and Central City. Zone 1, the fares increased. The one-way fares increased to $22 to $25 or $3. Zone 2, $26 to $30 or $4. In the round trip fare, those only increased by $1 in both zone 35 in 1 and 40 for zone 2. Rambling Express also provides and offers a 5 round trip pass for service from the same 2 zones, and that pass for zone 1 is increasing to from 122.50 to 125. That pickup point is in Lakewood. The other pickup point is in Aurora, and that one is being increased from 137.50 to 140. The owner of Rambling states that many of these 5 round trip passes are purchased by the casinos, distributed to their employees because they buy the majority of their multi-pass fares anyway. Financially, and for support, the owner stated it's the usual increases, insurance, driver wages, and fuel. Diesel fuel has gone up considerably in the last couple of weeks. The revenue from the service in 2025 was slightly over $6 million. The estimate from the increase of fares might increase it to almost 6.2 or a little over 135,000. Rambling's total revenues are over 17 million. It provides many other services. Also, from the number of trips, there are very few people that buy the one-way trips in Metro. Only about 600 the whole year. 50,000 of the trips. They sold approximately 34,000 of the passes in the past year. So I stated a little historical information if I could. The casinos opened in 1992, and as I was here in 1992, there were a lot of original applicants for this service, and even with the PUC, they thought there'd be a significant need for transportation to Central City and Blackhawk from the metro area, but all the other carriers who applied to the authority have stopped over the years, and Rambling is the only one remaining because the need wasn't near as significant as was estimated, but there's still some. Of course, I have a recommendation.
Yeah, we'd welcome the recommendation, and if you could speak up, that'd be great.
Okay, and also that the recommendation is to allow the 2 revised pages become effective on the proposed date, which is March the 2nd this year.
Commissioner Plant,
I agree.
Commissioner Gilman,
I also agree.
as do I.
Aye.
Thanks. Proceeding number 26A-0033 CPETA, Emerald Express Transportation, Mr. Foreman.
Good morning, Commissioners. Wyatt Foreman of your Commission Council. Before you is an application for rehearing, re-argument, or reconsideration, or RRR, filed by Emerald Express Transportation on February 5th, 2026, as well as a motion for leave to respond and response to the RRR, filed by Ski Town Transportation on February 9th, 2026. I'll start with a bit of brief background. On January 5th, Emerald Express filed an application seeking emergency temporary authority and temporary authority to provide call-on-demand shuttle service between Steamboat Springs and the Yampa Valley Regional Airport and between Craig and the airport. Emerald Express asserted there is a need for additional carriers in the area due to the expansion of the airport and a dispute between the airport and an incumbent carrier, resulting in there being only one call-on-demand shuttle CPCN holder providing services in the area, according to the applicant. By decision number C26-0041, the Commission denied the application, concluding it did not demonstrate an immediate and urgent need, and that there was existing common carrier service within the requested area, and therefore failed the twofold test outlined in Section 40-10.1-2041 and Commission Rule 6204, requiring a showing that there is an immediate and urgent need for the transportation services, and that there is no existing carrier capable of meeting the need. The decision noted intervener Ski-Town Transportation's existing CPCN, authorizing overlapping service, and also acknowledged that another carrier, Steamboat Shuttle Service LLC, had been granted authority but had not completed compliance requirements at the time. Emerald Express raises 3 issues on RRR that it asserts justify reconsideration of the Commission's decision. First, it argues the Commission improperly relied on the grant of CPCN authority to Steamboat Shuttle because at the time that carrier had not completed the required compliance filings, and moreover, because the decision granting authority has now been set aside. Second, Emerald Express asserts the Commission incorrectly stated the application requested only emergency temporary authority for 30 days. The carrier explains it requested emergency temporary authority or temporary authority for 180 days or both, and that the standards for each are different, such that it was error for the Commission not to analyze the application for a grant of temporary authority. And finally, Emerald Express maintains the Commission failed to consider all of the letters of support which were filed with the application. It points out the Commission's decision addressed only one of the letters, from the CEO of the Steamboat Chamber of Commerce, but that there were 3 other letters included in the application, and that it argues these letters strongly bolster the grounds for granting temporary authority. It asserts the Commission's failure to fully consider the letters of support justifies reconsideration. Emerald Express asks the Commission to reconsider its decision, grant the application, or in the alternative, rehear the application and allow Emerald Express to present argument on it. Ski-Town Transportation filed a motion for leave to respond in response to the RRR pursuant to Rule 1506B, which requires such a motion must demonstrate, among other things, a material misrepresentation of fact in the record or an incorrect statement or error of law. Ski-Town asserts Emerald Express's contentions that the Commission should consider the other letters of support and that these letters bolster support for temporary authority amounts to a material misrepresentation of fact because, it argues, the letters were dated 4 weeks prior to the application and are therefore stale and do not accurately reflect the situation on the ground when the application was filed. Ski-Town next asserts Emerald Express's argument that the Commission must consider both the application for emergency temporary authority for 30 days as well as a temporary authority for 180 days amounts to an incorrect statement or error of law. It argues the Commission cannot consider the application for temporary authority because under Section 40-10.1-204 subsection 4, temporary authority applications, unlike emergency temporary authority applications, must be noticed for a period of 5 business days. Ski-Town's response expresses support for the Commission's decision, reiterating the staleness of the letters of support and emphasizing Ski-Town has spent significant resources to meet the demands of the airport. And I can provide a recommendation first on the motion for leave to respond, and then can provide a recommendation on the merits of the RRR.
That'd be great.
Council recommends denying Ski-Town's motion. Under Rule 1506B, a motion for leave to respond to RRR must demonstrate a material misrepresentation of fact in the record or an incorrect statement or error of law. Council is not persuaded Ski-Town's motion satisfies this standard. Regarding the letters of support, Emerald Express's statement that they support the application for temporary authority do not seem to amount to the level of a material misrepresentation of fact, nor does the fact that the letters were dated weeks prior to the filing of the application. Emerald Express does not claim the letters were drafted contemporaneously with its filing and appears to be expressing an opinion about the strength of support provided by the letters. The Commission is capable of determining whether these letters sufficiently support a grant of authority as it did in the initial decision. And while Ski-Town's assertion regarding the notice requirement for temporary authority may be accurate, Emerald Express's contention that the Commission should have analyzed the temporary authority application does not seem to rise to the level of an incorrect statement or error of law warranting a response. And Council therefore recommends denying Ski-Town's motion for leave to respond. And I'll pause here for a vote on that issue.
Commissioner Plant,
I agree.
Commissioner Gilman,
Also agree.
as do I.
Thank you. And regarding the merits of Emerald Express's RRR, Council believes Emerald Express is correct that the Commission should have considered all 4 letters of support. Council believes that the fact that the initial decision did not address all of the letters and the fact that Steamboat Shuttle Services Authority has been set aside justifies reconsideration of the Commission's decision. However, even considering all supporting documentation and the pending nature of Steamboat Shuttle's authority, Council and advisors do not believe the application satisfies Rule 6204's immediate and urgent needs standard. Further, under Rule 6204A, subsection 2, any letters of support shall contain an explanation of the immediate and urgent need, whether there's any other transportation service available, and if such alternative is available, a detailed description of the author's efforts to use it, and whether it is capable of meeting the author's need, and the extent to which the available transportation service have refused to provide service. The letters of support here, while expressing enthusiastic support for Emerald Express generally, do not provide specific details regarding efforts to use other carriers or instances of having been refused service. In addition, the letters were dated multiple weeks prior to the filing of the application, and no letters were submitted to support Emerald Express's claim that the existing shuttle service is, quote, woefully insufficient to meet the need of the airport. Moreover, Ski Town's intervention opposing the application asserted that it has overlapping service authority with that requested in the application, that it had spent significant resources to expand its fleet, and that it still does not operate at full capacity. Council and advisors continue to believe the application could demonstrate a need for additional carriers in the area, but that does not satisfy the showing required for a grant of temporary authority. And to that point, Emerald Express's Triple R took issue with the commission addressing the application for emergency temporary authority, but not the application for temporary authority, arguing the standards are different. However, the standards are only different in the sense that the emergency temporary authority standard is higher. Under Rule 6204A, an application for temporary authority must include a showing of immediate and urgent need. And under Rule 6204B, an application for emergency temporary authority must include both a showing of immediate and urgent need as well as a showing of the basis and nature of the emergency. The Commission's decision found the application failed to satisfy the immediate and urgent need standard, and therefore necessarily found the application did not satisfy the requirements of either 6204A or B, and Council and advisors continue to believe the application does not satisfy this standard. Council therefore recommends the Commission grant the Triple R in part to reconsider the Commission's decision, but deny the Triple R in part to the extent it asks for a grant of the application or for the Commission to rehear the merits. Council also notes the decision is now pending in Emerald Express's application for permanent authority in proceeding number 25A-0202CP, in which an evidentiary hearing has already been held. And I can pause here for a vote or a discussion.
Commissioner Plant,
I would support the recommendation.
Commissioner Gilman,
I agree.
as do I. And that can be ABC decisions granting the Triple R in part and denying it in part and denying the motion for leave to respond.
Okay.
So thank you, Mr. Foreman. 25F-0270 CP, Mr. DeCenso.
Yes, good morning, Commissioners. Mitchell DeCenso of your Commission Council. Today, we'll briefly present a motion for leave to exceed the page limit filed on February 23rd, 2026 by pro se complainant Roman Lysenko. The motion accompanies exceptions that are 43 pages in length, not double-spaced and with narrow margins. When formatted in compliance with the Commission's filing requirements set forth in Rule 1202, the exceptions would exceed 60 pages. In the motion, the complainant contends that the exceptions and recommended decision cannot be understood without reference to various other proceedings and distinct issues, and therefore the additional length is necessary. The complainant alternatively requests a 7 to 10 day extension to refile the exceptions if the Commission denies the motion. And I can offer a recommendation this one, if that works.
That'd be great.
Council disagrees with the complainant's characterization of the recommended decision and issues in the proceeding, and the complainant has failed to demonstrate good cause to waive the requirements of Commission Rule 1202, which sets forth the Commission's filing requirements, including that pleadings be no longer than 30 pages in length. Accordingly, Council recommends the Commission deny the motion for leave to exceed the page limit and direct the complainant to refile exceptions in compliance with Rule 1202. Additionally, Council recommends giving the complainant an additional 7 days to refile the exceptions consistent with his request, with the standard 14-day response period beginning when the exceptions are refiled.
Commissioner Plant,
I agree with the recommendation.
Commissioner Gilman,
I also agree.
as do
Thank
I,
you.
and that can be an ABC decision. So thank you, Mr. DeCenso. 23M-0217R, Ms. Saba, RTD Oversight, Audit, and Investigations.
Good morning, Commissioners. Jessica Saba with the Rail Transit Safety Section. On February 19th, 2026, staff submitted a summary report on the investigations of 11 safety events involving RTD light rail and transit controlled property that occurred from October 1st, 2025 to December 31st, 2025. Staff's report summarizes the investigations and provides an analysis of the RTD safety events. The highest number of safety events occurred along the central corridor with 7 events. 7 events occurred in the central corridor. 5 of those events were passenger self-evacuations onto RTD's exclusive right-of-way. 4 of the 5 safety evacuations were from passengers self-evacuating the train. The last one was due to a power outage, and the supervisor escorted the passenger off the train to the nearest train station. The other 2 events were from trains hitting automobiles at the grade crossings. Both events occurred when the automobile entered the train's right-of-way. One event occurred in the Central Platte Valley corridor. This event occurred when a passenger self-evacuated the train into the Denver Union Station terminal. One event occurred in the Southwest corridor at the Elati train yard when a train derailed in the train yard when it attempted to go through an electric switch. 2 events occurred in the Southeast corridor. Both events were passenger self-evacuations of the train. Both happened due to power outages. In one of the events, supervisors escorted passengers to the nearest train station, and the second, passengers forced a train door open and walked out into the alignment. None of the safety events during this period resulted in injuries, required medical transportation, or vehicle tows. Staff have reviewed the accident reports from the fourth quarter of 2025 and found that they were completed in accordance with Rule 7349. I will pause for questions, or I can move to the recommendation.
If you can give us your recommendation, that'd be great.
Staff recommends the commission formally adopt the investigations reported submitted by the Regional Transportation District, Light Rail.
Commissioner Plant,
I agree.
Commissioner Gelman,
I also agree.
as do I. And do we have one more piece of this, Ms. Terry?
Oh, okay. Good morning, Commissioner. This is Cindy Osteri, State Safety Oversight Engineer. I will be discussing the fourth quarter corrective action plan CAP summary report that resulted from safety event investigation, edits, and hazard analysis. The staff report summarizes 2 new CAPs for commission approval for monitoring to closure and recommends closure of the 10 existing open CAPs. The first new CAP occurred in October 10. This CAP resulted from a yard derailment with the operator initiated the train wayside communication call while the train was still moving and did not come to a complete stop, causing the switch to return to its prior position beneath the vehicle and derailing the train. There were no injuries reported. The second CAP occurred in October 10. The CAP resulted from power loss that prevented the rails from moving on the de-energized track. The passengers were deboarded and to the closest station as soon as the MOW was able to restore the power. Through the discussion with RTD safety personnel and documentation review, the staff confirmed completion of the required elements of the 2 new CAPs. Unless there are any questions, I will proceed with the staff's recommendation.
That'd be great.
We recommend that the commission approve the monitoring to closure of the 2 new CAPs and approve closure of the 10 existing open CAPs listed in the CAP summary report.
Commissioner Plant,
I agree.
Commissioner Gelman,
I also agree.
as do I. And is there one more piece of this, Mr. Pierce?
Good morning, Commissioners. Jeremy Pierce from the Rail Transit Safety Section. On February 20th, 2026, staff submitted a summary report which identified 41 hazards related to the RTD light rail operations from 1 October 2025 to 31 December 2025. The staff's report contains a summary and analysis of RTD hazards and red signal violations. There were 33 reportable hazards and 8 signal violations. 1 reported hazard, as well as all 8 of the red signal violations, require corrective action, which will be reviewed through Cindy's program. Staff reviewed all hazards reports for the fourth quarter of 2025 and finds they have been completed in accordance with Rule 7350. I'll pause here for any questions or discussion.
Do you have a recommendation, or is it just to adopt the report?
No, sir, this report is for informational purposes only and no action is required by the commission at this time.
Commissioner Plant, any questions?
No questions. Thanks.
Commissioner Gilman?
No questions. Thanks, Mr. Pierce.
Thank you, Mr. Pierce.
Thank you.
With that, I think we can have an these ABC decision approving the monitoring of the two caps and closing the others. And we'll adopt the investigation reports and express our appreciation to Mr. Pierce. So thank you, sir. Let's take up the Black Hills Clean Heat Plan last. Let's take up the off-take issues with the JTS second to last. And let's move to 25 AL 0494E Public Service Company rate case. Ms. Friedman, Ms. Harper.
Good morning, Commissioners. I'm Ellie Friedman of your advisory staff. This morning, the Commission has several decisions regarding the procedural schedule and discovery procedures for this public service electric rate case. Also on February 20th, AARP filed a late motion for intervention that the Commission will address today. As to the procedural schedule, in decision number C250924, the Commission's order requiring the parties to propose a procedural schedule or provide a conferral report, the Commission noted that the evidentiary hearing must conclude no later than June 18th in this proceeding. On February 13th, Public Service filed a conferral report that offers two schedules. Option A sets a deadline of either April 21st or April 28th for answer testimony, rebuttal and cross-answer testimony due on May 20th, settlements, if any, on May 28th, and an evidentiary hearing that begins on June 11th and concludes on June 18th. Option B, offered by the parties, sets answer testimony due on April 28th, rebuttal and cross-answer testimony due on May 28th, settlements due on June 4th, and a hearing that starts on June 18th and runs through June 26th. The parties all indicate that option B is the preferred schedule. The Office of Utility Consumer Advocate states, however, that if option A is chosen, answer testimony should be due on April 28th, citing the Commission statement in decision number C250924, which was, the procedural schedule should also allow for adequate time for interveners to analyze additional data, and to the extent additional time is needed for the development of answer testimony, that time should come from the development of rebuttal testimony rather than shortening time for hearing or the deliberative process. Public Service opposes option A with procedural schedule that includes April 28th answer testimony deadline, stating due process concerns and asserting that the company needs 4 weeks to prepare rebuttal testimony. Colorado Energy Consumers suggest that an evidentiary hearing in July would allow the development of a well-supported and robust record in this proceeding, but states that it will work within whichever schedule the Commission adopts, and that statement is supported by Walmart. And finally, federal executive agencies oppose option A because of scheduling conflicts with its expert witness. So if you'd like, I can provide a recommendation at this time.
That'd be great.
Procedural schedule option A complies with the Commission's directive to conclude the evidentiary hearing by June 18th, allowing sufficient time for the Commission to deliberate, to hold a technical conference, and to issue a decision prior to the August 29th tariff suspension deadline. Additionally, since the company will not provide actuals for its proposed test year until March 24th, the answer testimony deadline of April 28th is appropriate. So advisors recommend adopting schedule option A with answer testimony due on April 28th and a technical conference and public comment hearings to be scheduled later.
Commissioner Plant.
I agree.
Commissioner Gilman.
I also agree.
As do I.
So to discovery procedures, the parties agree that discovery will be conducted in accordance with Rule 1405 of the Commission's Rules of Practice and Procedure, except that there will be a 7-day response time to any motions to compel, and work papers supporting pre-file testimony will be provided within 3 business days. Advisors recommend approving this discovery procedure as presented in the conferral report.
Commissioner Plant.
I agree.
Commissioner Gilman.
I also agree.
As do I.
And then so finally, on February 20th, AARP filed a late motion for leave to intervene. AARP states that it represents electric customers who are 50 years and older and who may be disproportionately impacted by the proposed rate hikes. AARP argues that its interests are unique and not adequately represented by other parties. The organization intends to examine issues such as distribution costs, coal plant expenditures, and performance incentive metrics. AARP explains that its filing was late due to administrative delays in obtaining representation and acknowledges that the official intervention deadline has passed. However, it emphasizes that the delay was not intentional and that it has no plans to disrupt the case schedule. AARP assures the Commission that its participation will not cause undue delay or prejudice to other parties and commits to accepting the existing procedural timeline as it stands. On February 23rd, AARP filed a supplement to its motion stating that UCA does not oppose its motion and Climax Molybdenum Company has no objection. Public Service, Colorado Energy Consumers, Sierra Club Energy Outreach Colorado, Core Electric Cooperative, the federal executive agencies, and the City of Boulder take no position. So unless you have any questions, I can provide a recommendation.
That'd be great.
AARP has demonstrated good cause for its delayed filing, and it affirms its participation will not disrupt the existing procedural schedule. Therefore, we recommend granting AARP permissive intervention in this proceeding.
Commissioner Plant,
Agree.
Commissioner Gilman,
I also agree.
as do I, and that can be an ABC decision setting the procedural schedule, including the hearing and discovery processes, and granting the motion for late intervention. Thank you, Ms. Friedman. 25A-0500E, Black Hills EDR, Mr. Davis, Mr. Sarah.
Good morning, Commissioners. I'm Ron Davis of the Commission's advisory staff. In late November of last year, Black Hills Colorado Electric filed an application for approval of a proposed economic development rate tariff. Black Hills filed their application pursuant to sections 40-3-1043, 6 and 7 of Colorado statutes, or what we informally call the EDR statute. The proposed EDR, as described in the application, is a 30% discount on base rate energy and demand charges for 10 years, plus exemptions from or discounts to certain riders, and a marginal cost energy cost adjustment. Black Hills also filed for an approval, a standard EDR customer contract, and a method to determine the marginal cost used to set the price floor for the EDR rate. Black Hills argues that by increasing load growth through the introduction of an EDR tariff, the company may assist in facilitating job growth in its service territory and potentially increase employment, salaries, and wages, as well as local tax revenues, while at the same time not causing cost increases to its existing electric utility customers. In December, the Commission set the application for hearing and required Black Hills to file supplemental direct testimony. The Commission later adopted a procedural schedule that culminates in a hearing next week on March 4th and 5th. This is an extraordinarily fast pace for an adjudication, but the EDR statute requires a Commission decision on the EDR tariff by mid-April. Last Thursday, Black Hills filed a settlement on its proposed EDR. The settlement is joined by both trial staff and UCA. The settlement is intended to resolve all EDR issues, as well as all issues that were or could have been raised by the parties in this proceeding with respect to the company's application. In brief, the settling parties agree to a 30% EDR discount on base rates and the transmission cost adjustment. The settlement states that Black Hills has demonstrated that the discounted rate exceeds marginal cost and is therefore reasonable and complies with the EDR statute. The marginal cost ECA for EDR customers, or the EDR ECA, would be set quarterly based on projected average fuel and purchase power costs, and it would be subject to a true-up comparing projected versus actual costs. Actual costs would be based on EDR customers' hourly load and corresponding hourly energy costs using what is called a bottom-of-dispatch stack approach. Black Hills agrees to update its marginal cost analysis every 2 years. Every 4 years, when there's an ERP filing, generation capacity cost assumptions will be updated consistent with a busbar study submitted in the ERP. In the interim non-ERP years, if capacity acquisition RFPs were issued in that ERP, for purpose of meeting a capacity needs, the marginal capacity costs would be updated based on phase 2 ERP bids. If executed ERD contracts exceed a combined 100 megawatts, Black Hills must request a commission variance, and this program cap would be reset when marginal capacity costs are next updated on that 2-year cycle. And finally, the settlement includes what are called customer protections. And these include hold harmless provisions, terms for delinquent payments, bad debt and losses, and a commitment that retail customers not be assigned any transmission or distribution interconnection or construction costs arising from EDR service. The settlement also includes requirements for an EDR customer to participate in at least one what is called a system benefit activity. Because of the settlement, the parties have asked that the evidentiary hearing scheduled for next Wednesday afternoon and all day Thursday either be shortened to just Thursday or vacated entirely. The settlement filed last Thursday afternoon came a day before the deadline for the filing of rebuttal testimony. Black Hills indicates that it will be filing testimony in support of the settlement and seeks an order from the commission modifying the procedural schedule to eliminate rebuttal testimony. The procedural schedule adopted by the commission sets next Tuesday, March 3rd, as the deadline for settlement testimony. And the parties ask you to eliminate the deadline for SOPs following the hearing. So this morning, you will decide whether to adjust the procedural schedule, and I can provide a recommendation if you'd like.
Yeah, if you want to give us a recommendation, but I'd like to keep at least the 1-day hearing, and then let's decide at the hearing whether we want to see a statement of position or not. I still have some questions, so I think that's consistent with your recommendation, Mr. Davis. But
I would suggest that the commission vacate the hearing on Wednesday, March 4th. I also suggest that the commission eliminate the rebuttal testimony from the procedural schedule. Because the settlement testimony has not yet been filed, the commission should retain the hearing on Thursday, March 5th, for that reason, at least in part. It would be fine for the commission to decide whether to require SOPs at the hearing. Because of the lack of rebuttal testimony, however, I do suggest that the commission in its order approving these requests that it expects Black Hills to offer a witness to speak to the settlement and explain why it represents a just and reasonable resolution of all issues in this proceeding, particularly since the record will not benefit from pre-filed rebuttal testimony that addresses, from Black Hills' perspective, the issues raised by staff and UCA. And this witness should also address why approval of the application as modified by the settlement is in the public interest and is consistent with the requirements of the EDR statute.
That makes sense to me, Commissioner Plant.
I agree. And just to be clear, so this would be, we'd be rescheduling the hearing just for Thursday, and would it be, I don't know if we need to pick a time and stuff now.
The order here can simply vacate the hearing on the 4th, and therefore it would start at 9 o'clock on the 5th.
Okay, great. Yep, I agree.
Commissioner Gilman.
I also agree.
As do I, and that could be an ABC decision. Mr. Davis, so thank you, sir.
Sure.
25A0548E, Black Hills SPP Markets Plus application. Mr. Davis.
Right. This is another procedural schedule to consider. On December 30th of last year, Black Hills filed an application for commission approval to participate in SPP Markets Plus. That's a day-ahead regional wholesale electricity market administered by the Southwest Power Pool. Black Hills' application is primarily to recover the associated costs through its energy cost adjustment. At its February 4th weekly meeting, the commission set the matter for hearing before the commission en banc and directed the three parties, Black Hills, Tri-State Generation and Transmission, and the Office of the Utility Consumer Advocate to confer on a proposed procedural schedule. On February 13th, Black Hills filed an unopposed motion to adopt a consensus proposed schedule that includes dates for the filing of testimony and a fully remote evidentiary hearing in late May. The proposed schedule also includes filing dates for pre-hearing motions, settlements, and corrections. The motion also explains that the parties have agreed that the Commission's rule governing discovery responses for direct and answer testimony should not be modified. So this morning, you will decide whether to adopt the proposed procedural schedule. And again, I could provide a recommendation if you'd like.
That'd be great.
I recommend that the Commission grant the unopposed motion to approve the procedural schedule without modification. Hence, the en banc hearing would be May 28th and 29th. The Commission should further adopt standard procedures for hearing exhibits for the remote hearing and extend the deadline for a final decision on the application by an additional 130 days pursuant to statute.
Commissioner Plant,
I agree.
Commissioner Gilman,
I also agree.
as do I. And again, that can be an ABC order granting the motion, approving the schedule, and extending the date by 130 days and waiving response time. So thanks, Mr. Davis.
Thank you.
26 AL-0056E, Mr. Dalton, Public Service TCA.
Good morning. My name is Bill Dalton, staff engineer. Can you hear me?
We can.
Today I'd like to present 26 AL-0056E, which is advice letter 2013 filed by Public Service Company of Colorado on January 30th, 2026 with an effective date of March 2nd, 2026. This instant filing reflects Public Service Company of Colorado's proposed revision to the existing 2026 transmission cost adjustment or TCA tariff sheet to correct for a formula error used in the determination of the original 2026 TCA rates as approved in advice letter 25 AL-0462E. This filing incorporates revisions to the 2024 true-up revenue requirements that was used to determine the 2026 TCA rates. Rate impacts. The average residential customer bill will increase by 13 cents per month or 0.212%. The average small commercial customer bill will increase by 16 cents per month or 0.11%. This revised advice letter or TCA tariff will increase the revenue for 2026 by $3.7 million above the existing $171 million expected. Concurrently with the advice letter filing, the company requested it and the commission granted the motion for approval of alternative notice regarding the advice letter filing in decision C-26-0089I. As of February 20th, no public comments or complaints have been filed. This recommendations, staff has reviewed the advice letters, work papers, and the accompanying tariffs. Staff recommends the commission take no action and allows this advice letter to go on the operational law. But first, do you have any questions?
Commissioner Plant, any questions? Are you okay with this going into effect by operational law?
I am good with that. Thanks.
Commissioner Gilman,
No questions. I agree with the recommendation.
as do I. Thank you, Mr. Dalton.
Thank you.
Ms. Rosati, Mr. Acera, Southwest Power Pool RTO West Regional State Committee.
Yes, good morning, commissioners. Wendy Rosati of your commission council. For your discussion today is whether to designate a commissioner to serve on Southwest Power Pool's Regional State Committee, or the RSC. The RSC is a committee within SPP's stakeholder and governance process. It is comprised of retail regulatory commissioners from the SPP footprint and operates on a one state, one vote basis. Pursuant to the RSC bylaws, each state commission with utilities participating in SPP may designate one commissioner or commissioner equivalent to the RSC. The RSC has primary decision-making authority over electric resource adequacy, transmission cost allocation, the inclusion of remote resources in the regional transmission plan, and the allocation of financial transmission rights. Because Tri-State will participate in SPP RTO West, when the market expansion begins operations on April 1st, 2026, a commissioner from the Colorado PUC may serve on the RSC. We recommend the commission designate a Colorado RSC representative through a short written decision. Chair Blank has indicated his interest in serving as the representative. We also recommend that for any controversial or Colorado-focused issues arising from RSC participation, council be consulted for procedural advice. Additionally, we recommend advisory staff assigned to work on RSC and SPP stakeholder issues consider periodic updates to the full commission and present such updates at a future CWM. With that background, I can answer any questions or turn it over to the commissioners for discussion.
Yeah, I'm happy to do this. It's beyond Tri-State and includes the munis and WAPA, but none of the IOUs. And as Ms. Rosati said, I'll do my best to work with council and Mr. Deaver to provide regular updates. But Commissioner Plant, anywhere you'd like to go?
I'm happy to volunteer you for the service on this board.
Wish there wasn't so much glee behind that, but Commissioner Goman.
I agree with Commissioner Plant, although it feels bad when you sound this terrible, but I agree that you should serve in this role, and yeah, I appreciate any updates you can provide as you move forward.
Just so you know, this is big progress from yesterday when I had no voice, so I was ready to have you run this meeting, Commissioner Goman. So thanks, Ms. Rosati, and to the extent you need a written decision, you can do it ABC.
Thank you.
Thank you. Let's jump back to the Public Service Company, JTS, what is it? 24A-0442E. Ms. Reedon, take us through this.
Thank you. Good morning, Commissioners. I'm Michael Eden with your advisory staff. So today I'll walk you through your deliberations in the Power Purchase Agreement, or PPA, litigation process. This process arises from Public Service Company of Colorado's proposal in the Just Transition Solicitation, or JTS, to implement a conforming bid policy in which developers can only submit bids that conform to the model PPAs approved in Phase 1. Over considerable opposition from independent power producer, or IPP, trade associations like CIEA, CEI, and Interwest, the Commission, in its Phase 1 decision, largely agreed with the benefits of a conforming bid policy. To develop a minimally negotiable set of PPAs, the Phase 1 decision resolved several of the key disputed issues. And then to finalize the PPAs, the Commission largely adopted the company's proposed PPA litigation process, pursuant to which the company would submit revised PPAs, parties would have an opportunity to submit comments and competing red lines, and then Public Service could file rebuttal comments and red lines. The IPP trade associations continue to oppose the conforming bid policy in their respective applications for rehearing, re-argument, and reconsideration, or RRR. In its RRR decision, the Commission granted in part these RRRs and adopted an alternative approach in which the Commission would rule on certain key disputed PPA provisions, but allow the remaining provisions to be negotiable. That brings us to today's deliberations. The Commission has before it extensive filings from Public Service, CIEA, CEI, Interwest, and Corsolis Energy, arguing for specific changes to the model PPAs. Consistent with the Commission's RRR decision, I'll attempt to quickly tee up the key provisions, and you can decide whether to adopt certain contractual language or direct that the provisions remain negotiable. So, without further ado, I'll start jumping through the list of the key provisions, starting with Section 2.2 of the Renewable PPA, and this deals with the renewal term. As you recall, in the Phase 1 decision, the Commission directed that Public Service create a right of last offer, or ROLO, for the renewal of the PPA at the expiration of its term. In the revised PPA, Public Service includes a new provision in Section 2.2 that allows the company to extend the term of the PPA with 6 months' notice and little ability for the IPP to negotiate terms of the extension. The IPP trade associations raised several critiques with Section 2.2. For instance, CIEA asserts that Section 2.2 would allow Public Service sole discretion to renew a PPA without a change in pricing, and that the 6 months notice is insufficient. Corsolis echoes these points. CEI and Interwest asked that Section 2.2 be struck entirely or substantially revised. In its reply, Public Service significantly reworked Section 2.2 in response to party feedback. For example, the company extends the notice period to 18 months and specifies that the parties must reasonably negotiate on the payment rate and committed energy requirements. If the parties are unable to reach agreement, then Section 2.2 grants the company a right of first refusal, or ROFO, and the details of which are specified in Section 19.5. Section 19.5 was provided for the first time in the company's reply comments. Would you like a recommendation on this point?
Yeah, we would.
Advisors agree with the language Public Service put forth in reply for Section 2.2, which is responsive to IPP feedback. We recommend the Commission direct this Section 2.2 be non-negotiable. Advisors also generally agree with the addition of Section 19.5, which we view as essentially creating a ROLO, consistent with the directive from the Phase 1 decision. However, Public Service did not propose this provision until its reply, so we have no feedback from the parties. Thus, advisors recommend the Commission commend the basic structure of Section 19.5, but direct that the exact wording be negotiable.
So I agree with the advisor recommendation, and I would just say this is a big issue for me, as we've seen projects and generators leave the regulated system for other buyers in ways that have greatly limited our options after 20-year long-term contracts. So I'm glad to see this make progress and support your recommendation. Commissioner Plant, anywhere you want to go?
I agree.
Commissioner Gilman?
I also agree.
Ms. Reed?
All right, jumping to Section 5.2, the model PPA set forth what happens if Public Service enters a market that impacts the deployment of the energy resource. In the Phase 1 decision, the Commission adopted a deductible approach in which Public Service reimburses the seller for capital expenditures once a $10 per kilowatt deductible is reached. And as you know, when I reference seller, that's the developer or IPP that executes the PPA and agrees to sell electricity to Public Service. Under the company's initially proposed language, the company reimburses the seller for costs incurred over the deductible at a rate of 1% per month for 100 months. The IPP trade associations all argue for significant modifications to Section 5.2. CEI and Interwest both recommend the Commission strike the new reimbursement rate and reimbursement timing language. CIEA likewise recommends deleting the 1% reimbursement language, but also recommends further changes. CIEA also asserts the deductible concept in Section 5.2 now conflicts with the change in law provision of Section 20.3F. In its reply, the company modifies Section 5.2 and Section 20.3 to resolve inconsistencies, and also changes Section 5.2 to address certain IPP concerns. The company largely maintains, however, the 1% per month reimbursement rate. And on this point, advisors agree with IPPs that the company's proposed 1% reimbursement rate is unreasonable. Advisors recommend the Commission adopt Interwest's proposed changes to section 5.2C, which strikes the 1% reimbursement language and direct that it be non-negotiable. Regarding the changes Public Service makes in reply to section 20.3F, no other party has had an opportunity to provide feedback on this new language. Advisors recommend the Commission expressly direct that section 20.3F shall be negotiable, but must not conflict with section 5.2C or any other Commission directive.
Makes sense to me, Commissioner Plant.
I agree.
Commissioner Gelman,
I also agree.
back to you, Ms. Reed.
All right, moving now to section 8.3, which addresses compensable curtailments. In the phase 1 decision, the Commission expressly approved the language in the 2021 ERP-CEP settlement regarding compensable curtailments. CIA argues that section 8.3, which contains the compensable curtailment language, would give Public Service the right to claim any type of curtailment is non-compensable. Interwest and CEI raised similar concerns, with CEI specifically asserting that section 8.3 should remain negotiable. In reply, Public Service rejects all of the proposed modifications, arguing that its current language is consistent with the phase 1 decision. Would you like a recommendation on this point?
Yeah, that'd be great.
Advisors recommend the Commission expressly state that curtailment provisions in section 8.3 are negotiable. In addition to the arguments raised by interveners, under the company's proposed language, curtailments caused by a declaration of an emergency are categorized as non-compensable. The term emergency, however, is essentially defined in the interconnection agreement, which Public Service could modify. Thus, even aside from the other concerns raised by the IPP trade associations, we don't have the record here to make section 8.3 non-negotiable.
Yeah, I mean, I think even if you modify the interconnection agreement, it's probably still needs some federal regulatory oversight. I mean, I don't disagree with the recommendation, but I just want to say for the record, I'm struggling with this issue of curtailment and compensable lost revenues and PTCs. The total curtailment in the low case with SEC in 2031 is 7,500 gigawatt hours. If we put a price on that of $50 a megawatt hour, the PPA price plus some PTCs, this is like a $400 million a year issue. Although I guess it could be lower if there's projects that come off the PTC like Rush Creek or Cheyenne Ridge. So I support the recommendation, but look forward to getting a better understanding of this issue in the April 2nd filing that should contain more detail. So basically agreeing with the recommendation, but would like that comment in the order. Commissioner Plant.
Yeah, I agree. I mean, I had some of the similar questions in looking at this, and it seems to me like, I mean, my number one sort of issue is that we need to have the same treatment for the IPPs as for the utility-owned projects, and if it's non-compensable, then you could reduce any compensation on the utility side from the revenue requirement, but we don't have anything in place for that right now. So it seems that, maintaining our, the existing system is the best way forward. I don't know, and you may know this, Mr. Chairman, but what do other states do? As if we're looking at, IPPs participating in Colorado versus, other states, do other states have curtailment compensated, or are you aware?
I mean, I could tell you what it was 8 years ago when I was doing this, but I don't know today what the market is. And I was going to touch on some of my comments at the end, which is, I mean, I found this process to be pretty frustrating in that there are market standards, but we don't know them from this record. there's a right way to do this, is just hire offtake counsel and figure out what market is and don't deviate from it except for extraordinary circumstances. But what we have here is a bunch of parties giving us litigation positions, and then we're doing our best to try and find the middle on what I would view and argue as an inadequate record. So I don't know, Mr. Eden, is there anything on this record that would tell us what other states do on this? Or are we flying blind?
No, I mean, I can't recall exactly the answer testimony that was submitted back in the initial JTS proceeding, but in terms of this PPA litigation process, no, there hasn't been any briefing about what other states are doing on compensable curtailments.
So I agree with the recommendation, just to clarify.
Yeah, thanks. Commissioner Gilman.
Yeah, I agree with the recommendation, and I'm fine with putting in some concern around upcoming curtailments in the decision, which I think was your recommendation. And I think that would probably be a good flag for us to really follow up on this issue in other proceedings, both in terms of resource acquisition, but also in terms of rate structures and options. I think certainly like how you treat curtailment on the generator side is one solution to a problem. I think what we're facing here is it's a pretty anti-competitive solution to that problem, which may result in different treatment for IPPs than company owned. And so I think it would be very helpful as we move forward. We can certainly flag this issue in the decision, but then really focus on what are some other solutions or remedies as we look at rate structures or other ways to make better use of this abundant energy at certain times of the day. Just moving forward more strategically with that.
So, Mr. Eden, if you could also put some language in the order stating the commission's preference that IPPs and the company be treated in the same way and subject to the same risks to the extent reasonably possible, that'd be great.
Okay. So next is Article 11, addressing security. In the Phase 1 decision, the Commission agreed with Public Service to make the security provisions non-negotiable, but directed the company to lower the upfront security amount. In accordance with the Phase 1 decision, Public Service lowered the security amount, but largely maintained the language of Article 11. The IPP trade associations continue to request modifications to other provisions of Article 11 regarding when and how the company can draw from the security fund and the options a seller has to provide security, for example, a letter of credit or surety fund. I'll address each of these issues in turn. The first disputed security provision is Section 11.1C, which details how the company can draw from the security fund. CIEA and Interwest both propose requiring Public Service to first provide notice and an invoice before drawing from the security fund. In its reply, Public Service rejects this addition. Advisors recommend rejecting CIEA and Interwest proposed modifications to Section 11.1C. Their proposed language is not present in the 2021 ERP CEP model PPAs and appears unnecessary.
Commissioner Plant.
I agree.
Commissioner Gilman.
I also agree.
As do I.
Thank you. The next disputed subsection is 11.3C, which sets forth the standards for security via a guarantee from a parent company or other entity. CIEA adds language limiting the company's discretion to reject the guarantee. In reply, the company only partially responds to CIEA's concerns. And here, advisors recommend adopting the language in Section 11.3C from the 2021 ERP CEP. This language addresses CIEA's underlying concern and is less complex than the language Public Service proposes in it.
Commissioner Plant.
I agree.
Commissioner Gilman.
I also agree.
As do I.
Next, CIA and Interwest both request adding a provision in section 11.3 that would allow sellers to satisfy the security requirements via a surety bond. In reply, the company summarily rejects this proposal. Advisors agree with the company's position and recommend rejecting the option for a surety bond. The PPAs already provide several different options to post security, and the surety bond concept is not present in the 2021 ERP CEP.
Commissioner Plant,
I agree.
Commissioner Gilman,
I also agree.
as do I.
CIA and Interwest also oppose language in section 11.4 regarding the replacement of security. For instance, Interwest argues the requirement to replace the security fund should only be triggered if the security fund actually fails to comply with section 11. The company summarily rejects these proposed changes from CIA and Interwest. Advisors again agree with Public Service and recommend rejecting the proposed changes. Public Service's language puts appropriate guardrails on the company's discretion, and that the company's determination must be commercially reasonable. In addition, the concept that the seller must replace the security fund if an event threatens to cause the security fund to fail is also present in the 2021 ERP.
Commissioner Plant,
I agree.
Commissioner Gilman,
I also agree.
as do I.
All right, so moving on, CIA and Interwest recommend changes to section 11.6, which generally requires the seller to reimburse the company for legal fees associated with handling the security fund. CIA and Interwest recommend specifying the seller will reimburse reasonable and documented fees. In its reply, the company agrees to add documented, but rejects the term reasonable. Here, advisors recommend adopting Interwest's language in section 11.6 that specifies that the legal fees must be both reasonable and documented.
I have to argue against reasonableness, Commissioner Plant,
I agree.
Commissioner Gilman,
Yeah, I agree. I think an expectation that they be reasonable is pretty fair. So I agree with your recommendation.
keep going.
All right, and then finally, subject to all of the changes to Article 11 we just went through, advisors recommend the Commission specify that Article 11 shall be non-negotiable.
I agree with that. Commissioner Plant,
I agree.
Commissioner Gilman.
I also agree.
All right, so moving to section 12.1A, which lists several events that could cause a default if not cured, including a seller's failure to produce a certain amount of committed energy from the energy resource. In the Phase 1 decision, the Commission agreed that section 12.1A should be non-negotiable, but directed the company to make several changes. The IPP trade associations all request numerous revisions to section 12.1A. CIA, in particular, argues Public Service made unauthorized changes to the wind and solar performance criteria that conflict with the 2021 ERP settlement agreement. CEI and Interwest also request significant changes to section 12.1A, which for the sake of time, I won't go through here. In its reply, Public Service characterizes CIEA's allegations of unauthorized changes as spurious. According to Public Service, nothing requires the company to use the PPA terms agreed upon in the 2021 settlement agreement. Public Service also substantively disagrees with the various requested changes to the performance metrics in section 12.1A. So on this point, except for the Phase 1 decision's prior directives regarding section 12.1A4, advisors recommend the Commission expressly find that section 12.1A is negotiable. This section covers several technical requirements that exemplify the type of provisions that are better suited for project-by-project negotiation. Moreover, it remains unclear whether the company's proposed terms for things like committed energy are reasonable. On this point, the Commission should encourage the company to apply the committed energy and availability standards in the model PPAs when the company formulates its pricing for any company-owned projects. The Commission should signal its intent to match the operational PIM to the standards public service requires of IPPs. Public service should be prepared to disclose the performance requirements from the executed JTS PPAs and the follow-on CPCN proceedings for company-owned projects, so that the Commission and parties can ensure both ownership types are being held to equivalent performance requirements.
Commissioner Plant,
I agree.
Commissioner Gilman,
I also agree.
as do I.
Okay, moving to section 12.2, there are several disputed provisions in this section which address the consequences if an energy resource fails to achieve the commercial operation date, or COD. I'll address each of these in turn. So section 12.2 sets out detailed steps a seller must take to cure a COD delay and avoid defaulting under the contract. One such step is the prepayment of liquidated damages for each day the seller estimates missing the COD. CEI, Interwest, and CIEA all request modifications to the default provisions associated with COD delays. CIEA specifically asserts that requiring sellers to prepay liquidated damages is out of market and onerous, especially because sellers already have to prepay the security fund. Public Service opposes changing the prepaid liquidated delay damages concept. On this point, advisors agree with CIEA that requiring developers to prepay liquidated damages on top of the required security fund is excessive. This concept introduces several stringent requirements that were not present in the 2021 ERP. In addition, the new prepayment provisions add little, if any, protections for ratepayers because the company already has access to the security fund. Instead of the language set forth in the JTS PPAs, advisors recommend the Commission largely adopt the language from the 2021 ERP as modified to maintain the updated terminology and the 180-day cure period from the JTS.
Commissioner Plant,
I agree.
Commissioner Gilman,
I also agree.
as do I.
Thank you. Next, I argues that there is no provision that addresses what happens if the company chooses not to terminate the PPA under section 12.2C, but the seller is unable to achieve COD. According to CEI, in this circumstance, the company could run up liquidated delay damages in perpetuity. Public Service opposes CEI's position. Advisors are persuaded by CEI's concern. To address this issue, the Commission should require Public Service to add a sentence in section 12.2C specifying that in no event will the liquidated delay damages accrue for more than 180 days, which is the maximum length of the cure period.
Commissioner Plant,
I agree.
Commissioner Gilman,
I also agree.
as do I.
Thank you. So more generally, CEI asserts the liquidated damages provisions remain very high and do not ladder or scale. CEI asks the Commission to consider an alternative percentage of revenue approach for liquidated damages. CIEA likewise proposes significant additions to section 12.2 that would allow a seller to delay the COD without penalty for things like an import restraint or transmission delays. CIEA and Interwest both recommend capping the damages under section 12.2C at $62.5 per kilowatt. On this point, other than the above changes we've gone through, advisors recommend rejecting the other proposals from the IPP interests and maintaining section 12.2 as non-negotiable. Advisors view this recommendation as consistent with the phase 1 decision in which the Commission found that forfeiture of 50% of the security deposit, in addition to costs and damages accrued prior to the termination date, to be a reasonable consequence for failing to meet the COD.
Commissioner Plant,
I agree.
Commissioner Gilman,
I also agree.
as do I.
Finally, the JTS PPAs establish liquidated delay damages of $250 per megawatt for each day an IPP project is delayed. Under the Commission's rulings today, this $250 per megawatt per day liquidated delay damage would be non-negotiable. To ensure more equal treatment between PPA and company-owned projects, the Commission should direct the company to fashion its bid prices in Phase 2 of the JTS under the assumption that the company will experience a disallowance of $250 per megawatt for each day the company's project is delayed.
Commissioner Plant,
I agree.
Commissioner Gilman,
I also agree.
as do I.
Thank you. So now we're at Article 14, which addresses those instances in which a developer can be excused from contractual performance by reason of force majeure. Starting with the transmission authority delays, in the Phase 1 decision, the Commission directed Public Service to modify the PPAs such that any transmission authority delays expressly constitute an event of force majeure. In the company's revised PPAs, transmission authority delays constitute force majeure except to the extent any such delays are caused by an emergency. The definition of emergency is contained in the interconnection agreement, which the company did not provide as part of the PPA litigation process. CIEA proposes modifying the new language such that emergencies do not prevent a finding of force majeure, but the company opposes this change in its reply. Advisors recommend adopting CIEA's proposed modifications and striking emergency as a reason why a delay or failure by the transmission authority would not be a force majeure event. The company has not established why force majeure protections should be removed if an emergency causes a transmission-related delay.
Commissioner Plant,
I agree.
Commissioner Gilman,
I also agree.
as do I.
The next issue involves Section 14.1J, which addresses changes of applicable law. CEI argues the change in law provision should be expanded to cover changes in law that make performance uneconomic. CIEA suggests the company revise language for changes in applicable law go beyond the Phase 1 decision's directives and conflicts with Section 20.3F. Corsolis argues the company's proposed language in Section 14.1J is insufficient for new natural gas facilities, which may face new requirements for carbon sequestration and storage technologies. Public Service opposes these recommended changes. The company asserts the proposed changes would amount to full walkaway rights. Advisors recommend the Commission adopt Public Service's proposed change of law language in Section 14.1J for purposes of the renewable PPA, the storage PPA, and the hybrid PPA, and direct that this provision be non-negotiable. We find arguments from CEI and CIEA to be unpersuasive. As for the dispatchable PPA, advisors are sympathetic to Corsolis's arguments, but agree with Public Service that Corsolis's proposed language is too broad. Given the value of encouraging more PPA thermal projects and the unique risks thermal projects face regarding future changes in law, advisors recommend allowing parties to negotiate Section 14.1J of the dispatchable PPA.
Commissioner Plant,
I agree.
Commissioner Gilman,
I agree, and I don't think there's a future point, Ms. Treen, but correct me if I'm wrong. I also see some implication to what we consider here as being negotiable or not with regard to force majeure and different circumstances that could lead to changes in price, having some implication for company-owned projects and interpretations of similar provisions as we look at cost containment mechanisms for company-owned projects. So I don't know if that's reasonable addition to you, Mr. Eden, but just wanted to bring that up as a related issue.
Are you talking about, just so I'm clear, in regards to a force majeure event being similar to an event of extraordinary circumstances that
exactly company arguments for changes in price after bid for company-owned projects, and to me they should live by similar means as what we are expressing for appropriate reasons that costs could change for IPPs as well.
I guess I don't disagree. Just worry that the company will start pushing to make it all as too loose to protect the company-owned projects. But I'm okay with the resolution of this one. Commissioner Plant,
I agree.
does that give you what you need, Mr. Eden?
Yeah, I can throw or add language to in the decision, drawing that parallel between the standards of the PIMs and force majeure standards in the PPAs. In the company's revised PPAs, for a seller to avail itself of force majeure protections, it must provide notice of force majeure to the company no later than 10 business days after such party becomes aware of or acting reasonably should have become aware of the occurrence of force majeure. CEI argues the trigger for force majeure should be based on awareness of the impact, not awareness of the event itself. Alternatively, CEI argues the last sentence of section 14.2 should be changed to provide a waiver of relief only for the period of time by which notice of force majeure was late. CIA proposes modifying the trigger to be 10 business days after the party becomes aware of the force majeure, as opposed to when a party becomes aware or should have reasonably become aware. The company opposes the recommended changes. Advisors recommend rejecting CEI's requested change to trigger the 10-day period on when there is awareness of the impact of the force majeure event. The company's current language is consistent with paragraph 452 of the Phase 1 decision. We likewise recommend rejecting CIA's request to strike the language or acting reasonably should have become aware. Requiring public service to prove actual knowledge would be unduly burdensome.
Agree with that. Commissioner Plant,
I agree.
Commissioner Gellman,
I also agree.
Mr. Eden.
All right, under section 14.3C, the company may terminate the PPA if the force majeure continues for a certain length of time. CIA and Interwest both request the commission modify section 14.3 so that the seller could also terminate the PPA if force majeure continues for a certain length of time. Here, advisors recommend rejecting these requests and maintaining the current language, which mirrors the language from the 2021 ERP. It's unclear why a seller that is excused from performance by reason of force majeure would also need the ability to terminate the PPA.
Commissioner Plant,
Agree.
Commissioner Gellman,
I also agree.
as do I.
So to wrap up Article 14, except for the changes discussed above and Section 14.1J in the dispatchable PPN, advisors recommend adopting the company's force majeure language in its reply for Sections 14.1, 14.2, and 14.3, and directing that these provisions be non-negotiable. This recommendation is generally consistent with the directives and rationale of the Phase 1 decision that the PPA should strictly limit when a developer can be excused from performance by reason of force majeure.
Commissioner Plant,
I agree.
Commissioner Gellman,
I also agree.
as do I.
All right, so now we're going to move down to Section 14.4, which is the new trade measures provisions. The Phase 1 decision adopts, with modifications, the tariff pass-through mechanism that staff proposed during the JTS proceeding. To implement the tariff pass-through mechanism, Public Service added Section 14.4, the new trade measures events. The IPP trade associations raised several concerns and proposed modifications to Section 14.4, all of which the company rejects. Advisors recommend the Commission provide additional directives regarding Section 14.4 to help resolve some of the most significant controversies. And I'll just start moving through those individual topics. As initially proposed, under the tariff pass-through mechanism approved in the Phase 1 decision, bidders, including the company, are required to set forth their estimated current and known tariff estimate, or CKTE, with their initial bid submission to serve as a baseline. This concept is not expressly referenced in the company's PPA language. Rather, it appears the CKTE would first be provided after a new trade measure when the seller is seeking a price adjustment. Advisors recommend reiterating this concept and directing public service to include in the RFP package the appropriate directives to implement the tariff pass-through concept as approved in the Phase 1 decision. The Commission should likewise direct the company to ensure that the PPA language explicitly ties the opportunity for price flexibility to the baseline CKTE and supporting materials that were submitted at the time of bidding. Finally, the Commission should clarify that this same standard applies to company-owned projects.
Commissioner Plant,
I agree.
Commissioner Gelman,
I also agree.
as do I.
Moving to the selection and cost of the independent auditor, under the company's proposed PPA language, the individual IPPs must retain and pay for their own independent auditor, or IA, which would verify the change in tariffs and ultimately approve or deny the requested price increase. CIEA opposes requiring IPPs to pay for the IA. Instead, CIEA argues the IA that was previously retained as part of the CEP delivery process should be used. Costs associated with this IA are recovered via the Electric Commodity Adjustment, or ECA. Public Service opposes CIEA's request, arguing that IA costs should not be borne by customers. Here, advisors recommend the Commission direct Public Service to use the structure of the CEP delivery plan to select a single IA that will review all requests, both from IPPs and the company, for price relief based on new tariffs. As in the CEP delivery plan, the costs associated with this IA can be recovered through the ECA or another appropriate rider, but the company should file a motion for IA approval after conferral with staff and UCA. Having one single IA will likely produce more consistent results than individual IAs for each project. Advisors are concerned that Public Service's proposal is to require IPPs to pay for the cost of the IA, but the company would have ratepayers fund the cost of the IA for purposes of company-owned projects via the ECA. If so, this unfortunately gives credence to allegations from IPP interests that Public Service takes an overly aggressive posture in PPA negotiations.
Commissioner Plant,
I agree.
Commissioner Gelman,
I also agree.
as do I.
Moving to the timing of IA determinations, under the company's proposed language, if an IA fails to make a determination within 180 days of receipt of the seller's request for price flexibility, the seller's requested price increase is automatically rejected. Interwest argues that the parties should be able to jointly replace the IA if it fails to make a timely determination. CIEA proposes flipping the company's concept so that if the IA does not make a determination within 30 days, the seller's requested price increase automatically is granted. As I noted above, Public Service rejects all of the proposed changes in its reply. And here, advisors disagree with both Public Service and CIEA. The IA's ability to make a timely determination should result in neither an automatic denial nor approval of the requested price adjustment. The Commission should allow the parties in Public Service to negotiate the best process for ensuring the IA makes timely determinations, and resolution of this issue may involve increasing the number of days the IA has to reach a determination. Regardless of the resolution, the Commission should direct that the same standard apply equally to both IPP and company-owned projects.
Commissioner Plant,
I agree.
Commissioner Gelman,
I also agree.
as do I.
So moving on to the 10% cap, consistent with the Phase 1 decision, the company's language sets a 10% cap for price increases associated with new tariffs. CEI argues this 10% cap means very limited relief is available. CEI proposes an alternative framework with a $100 million limit and no fault termination right if price increases go beyond that. Public Service opposes CEI's alternative framework, asserting it would grant new walkaway rights and also subject the company to prudence review risk on any negotiated pricing changes. Advisors agree with the company and would reject CEI's alternative proposal. The Commission should empathize that the 10% cap is non-negotiable and that IPPs have no right to walk away from a project if it experiences tariff impacts of more than 10%. Likewise, absent Commission action, IPPs should not have the ability to obtain price relief greater than 10%. At the same time, the company's current language omits an important concept. As proposed by staff and adopted in the Phase 1 decision, when the total project costs exceed the cap, the project should be reconsidered via a notice and review process rather than automatically terminated. This concept recognizes that tariff prices might increase the cost of all projects and that letting the initially selected projects fail may ultimately require the approval of a more expensive backup project. In keeping with the intent of the Phase 1 decision, advisors recommend requiring Public Service to expressly include this concept in the PPAs.
Commissioner Plant,
I agree.
Commissioner Gilman,
I also agree.
as do I.
Thank you. Under the company's proposed language, price relief is limited to, quote, new trade measure events, end quote, such as new tariffs, duties, or other trade measures. CEI argues that a similar price adjustment mechanism should exist for changes to tax law. Likewise, CIA proposes changing the definition of new trade measure event to include changes to tax law. Public Service opposes these arguments to expand the tariff pass-through mechanism. Here, advisors agree with Public Service and recommend rejecting the request from CEI and CIA to incorporate changes in tax law. When staff proposed the tariff pass-through mechanism, it specifically warned against expanding the mechanism to cover changes in tax law.
Commissioner Plant,
I agree.
Commissioner Gilman,
Also agree.
as do I.
Thank you. To conclude this section 14.4, advisors recommend the Commission expressly direct that the new trade measure concept, as well as the associated definitions, remain negotiable. The language put forth by Public Service, even considering the requested amendments from the IPP trade associations, does not allow the Commission to easily approve non-negotiable language that fairly implements the approved tariff pass-through mechanism. Instead, advisors recommend the Commission direct Public Service to negotiate the language in section 14.4 consistent with the Commission's directives and guidance, and remind Public Service that the company should expect that any standards ultimately required of IPPs, for instance the 10% cap, will also be required of company-owned bids.
As long as the 10% cap is non-negotiable, consistent with your prior recommendation, I'm good with that. Although you just worried if the company get in trouble, we just start loosening the standards too much. But subject to that, Commissioner Plant,
Yes, I agree.
Commissioner Gilman.
I also agree.
All right, take us home.
We're getting closer. That takes us now to sections 19.3 and 19.4, which address transfer limitations. Under section 19.3, whenever an IPP wants to sell a project after the COD, but before the end of the PPA term, it must offer Public Service a right of first offer. Similarly, under section 19.4, the IPP must give Public Service at least 90 days notice of any pending facility transaction, or PFT, that does not otherwise trigger the company's right of first offer rights under section 19.3. CEI argues that certain language in section 19.1b is highly problematic and does not capture the Commission's directives. CEI also opposes the additions Public Service makes to what is required for a right of first offer notice, arguing that the level of specificity would preclude sellers from granting exclusivity to alternative third-party purchasers. CEI and Interwest argue that Section 19.4 regarding PFTs remains problematic and should be struck. CIEA advances significant changes to Section 19.3, including a proposal to eliminate provisions that would apply the right of first offer concept to the seller's parent. Public Service rejects the various IPP recommendations regarding Section 19.3 and 19.4, arguing that its current language complies with the Phase 1 decision. In its reply, the company also adds Section 19.6, which relates in part to the right of first offer in Section 19.3. Here, advisors note that the Phase 1 decision directs that the right of first offer and the PFT provisions in Section 19.3 and 19.4 be included in the PPAs, but allows the parties to negotiate the details. Thus, advisors recommend denying requests to strike Section 19.3 and Section 19.4. However, the Phase 1 decision also directs that the right of first offer in Section 19.3 either be converted to a right of last offer or require the use of a third-party appraisal to ensure fair valuation of the project. These directives are not incorporated into the company's revised PPA language. The Commission should reiterate these directives, especially because CEI raises similar concerns in its response comments. With these clarifications, advisors recommend the Commission continue to designate Section 19.3 and Section 19.4 as negotiable. Similarly, advisors recommend the Commission denote Section 19.6 as negotiable, given it was proposed for the first time in the company's reply comments.
Commissioner Plant,
I agree.
Commissioner Gellman,
I also agree.
as do I.
Okay, now we're at Section 8.1 in the model dispatchable PPA, which sets out the formula for how to calculate the contract capacity payments. Section 8.1 enumerates certain exceptions in which the unavailability of a plant will not reduce the capacity payments. In its response comments, Corsolis argues that one such enumerated exception should be those instances in which the company requires the seller to use fuel oil. Corsolis reasons that when fuel oil is used, it will impact the availability of natural gas generation. Corsolis puts forth its recommended revisions in Section 8.1b3. In its reply, Public Service adopts Corsolis' suggested revisions. Advisors recommend the Commission commend Public Service for incorporating Corsolis' recommended change, which advisors view as an improvement. Nevertheless, advisors continue to recommend the Commission direct that the dispatchable PPA remain negotiable, except as to those terms the Commission has expressly required to be non-negotiable. The model dispatchable PPA should be based on the company's reply version, including the changes made to Section 8.1b3 regarding the capacity payment, and is modified to comply with the Commission's directives and guidance.
Commissioner Plant,
I agree.
Commissioner Gellman,
I also agree.
as do I.
Okay, and then finally, to wrap this all up, for the upcoming JTS RFP, advisors recommend directing the company to use the model PPAs it provided in its reply as modified by the Commission's directives and guidance. In the model PPAs provided with the RFP, the company should be required to highlight all of the non-negotiable provisions consistent with the Commission's directives. For all other negotiable provisions, IPPs should be allowed to submit red lines consistent with past practice. The RFP package must explain this distinction so that bidders are clear where they can and cannot submit red lines. While portions of the PPAs remain negotiable, the Commission should reiterate that the final PPAs must conform to the Commission directives. For instance, attempting to reinsert concepts like specific performance or critical path development milestones during PPA negotiations would be contrary to Commission directives.
Commissioner Plant,
I agree.
Commissioner Goman,
I also agree.
as do I. And just have some final comments. I think that's our last issue, Mr. Eden.
That's correct, yeah. And then deciding whether it should be a ABC or TBC decision.
I think you better make this one TBC if that's okay.
Sure.
I just want to say one final thing, sort of responding to Commissioner Plant's question about, well, what do other states do? Just think this has been a really frustrating process. And in an ideal world, we'd engage National Offtake Council to inform the commission and the parties what the market generally is for key terms, and then only depart from market for extraordinary or compelling reasons. But as we go through the items, this record really doesn't tell us what other states do or what market is, and we're just left trying to sort through everybody's litigation position, which isn't great. And in the case of compensable curtailments, could create, maybe multi-billion-dollar potential liability for existing customers. I don't have a solution today, but after going through the process, and this may be more the cold talking than anything else, I'm beginning to wonder whether we should just let the large new loads contract directly with, IPPs and the unregulated power producers, and get this commission and existing customers and the regulated rate-based system out of the middle. The pace and scale load growth from large new loads, as well as the detailed contract terms, could then be something that is best addressed maybe outside the regulated system, at least for the clean energy acquisitions. So it's maybe a knee-jerk reaction to this deliberation and some of the things we've seen, but just thought I'd throw that out there. So any final thoughts, Commissioner Plant?
No, nothing additional.
Commissioner Goin?
Maybe just a follow-on question for you. Is that something you envision being taken up in the large load tariff context, or that's just commentary?
Yeah, just exhaustion and frustration more. I wouldn't put anything in the order, and I haven't talked to advisors or counsel, and it may require legislation. So just frustration more than anything else with the records. We're trying to make this decision and, throw it out to stir the pot and see if the parties want to think it through. But I'm not suggesting it be litigated in the large new load tariff, and I haven't personally thought it through. Just frustration. So.
Yeah. I mean, I don't disagree. I'm not sure what you personally were hoping for out of this process, but
just want to know what market is, right?
Yeah. No, but it's a
there is
difficult place.
market, and it's definable. People can tell you what it is, but nobody really. We don't have a process to let us know what market is, right? It's just sorting through litigation position.
Yeah, I think this is truly a difficult place for the commission to be. Clearly we saw delays and things in the 2021 ERP CEP that we're trying to remedy. But this is only one possible remedy to make these negotiations more efficient, which is clearly what we heard from the company. And I will know we've tried to make another process to hear more directly from bidders on what's actually going on in those negotiations, what's taking so long, what the sticking points are. And it's made more difficult in that some of the provisions can be seen as anti-competitive, and so we have to weigh, how we're treating company projects and IPPs and ensuring we expect the same performance, we expect the same financial penalties. And I think it really truly is a difficult place to be, not just with kind of the ever-changing federal policies and tariffs that we have to deal with here, but also in ensuring that we don't really increase the risks or burdens of the IPPs to the point where we're just making kind of all bids more expensive. kind of in the vein of trying to protect customers, that is a potential repercussion of going too far. So I think that's really what we've been trying to balance here in ensuring, that we have something that reasonably protects customers and provides a reliable path forward, but doesn't go so far that we're seeing all prices rise. So, it's a difficult and somewhat dissatisfying place to be trying to call the balls and strikes ahead of time. Also, not truly understanding from the prior ERP process how much are we remedying here. So I think hearing from those IPPs in the JTS will be very helpful to get a much fuller picture of what's really going on during these negotiations.
Yeah, maybe that's a more useful suggestion than mine, kicking over the whole process. But maybe it is worth having trial staff or REI or some combination reach out to the bidders in a confidential process and see if we can learn, in a little more detail how things go or are going. So maybe that's an idea to take up elsewhere. I don't know. Well, thanks for the conversation. Why don't we take like a 10-minute break till 10:55? And Mr. Eden, if I can call you, I have one thing for you. So 10:55. All right, Mr. Mendelson, proceeding number 23A-0633G, Black Hills Clean Heat Plan, my favorite case.
Alrighty, hello commissioners. I'm Mike Mendelson of your advisory team. I'm joined by Lindsay Dundas of your commission council. Today's discussion is a continuation of deliberations that began on January 14th. At that CWM, the commissioners voted to reject the second settlement associated with Black Hills Clean Heat Plan. That document closely mirrored the first settlement, which was formally rejected via Order C-25-0091. However, the Commission also discussed finding ways to preserve some aspects of the company's proposed clean heat plan, including investment in DSM and potentially investment in beneficial electrification beyond the proposed Rocky Ford pilot. With respect to DSM and its January deliberations, the Commission seemed to affirm the spending guardrails established in the C-25-0091 decision that incremental DSM investment could support weatherization or envelope efficiency above current building code, and that equipment incentives were allowed where a gain in equipment efficiency was provided. That is no like-for-like replacement. However, the Commission did not come to final determination regarding a DSM or BE budget. The Commission also delved into the issue of third-party administration of the company's BE and DSM programs as proposed by SWEEP. The Commission also agreed to reach out to CEO to initiate a collaborative process to inform and potentially find commonality on SEAMS issues amongst public and investor-owned electric and gas entities. And the Commission also agreed to not fund AMLD or RNG investment, though I will ask you to confirm those decisions today. For reference, the second settlement proposed a 2-year budget of $12.4 million, $8.8 million of which would be spent on DSM. 20% of that DSM budget would go to income qualified customers. Another $2.1 million would be spent on AMLD, $700,000 on RNG, and $300,000 plus each for the thermal pilot feasibility study and the electrification study. SWEEP's proposed budget was more than twice that of the settlement parties, $28 million versus $12 million, and would be approximately divided in half between DSM and BE. Also, as referenced, the company's 2024 DSM budget was $5.4 million, and the company spent 18% higher than that projected amount. So I'll go now into the decision points. I believe we're keeping the clean heat plan. But want to go over that decision C-25-0091 limited DSM spending to envelope measures and eliminated equipment replacement. The parties ignored these concerns. The second settlement proposed $8.8 million, as I mentioned, and SWEEP supports restricting the use of all clean heat funding, clean heat DSM funding to building envelope weatherization and other measures that do not directly fund new gas equipment, such as pipe insulation, smart thermostats, and water savings measures, because Black Hills has not shown that its gas equipment incentives reduce emissions. So the decision point for you now is, does the Commission approve or require DSM spending as part of this CHP process? And if so, does the Commission maintain the same restrictions from the C-25-0091 decision? And what specific budget should be applied to the DSM spending?
Well, why don't I turn to you first, Commissioner Gilman? Hopefully you see a way through this, because I don't have a great one.
Yeah, certainly interested to hear your perspectives, including Commissioner Plant, as I know you were focused somewhat on the envelope-only incentives. For me, I can see kind of a range of perspectives here on the DSM. Probably my most primary concerns are that there's a significant potential that we're funding any number of like-for-like replacements on gas-fired equipment. Sorry, which I think is the most acute concern, as well as, if it meets the intent of clean heat statute to be funding the equipment at all, which was something we addressed in our first decision here. But probably the more acute issue for me is to disallow the funding of like for like equipment. So at a minimum, I think we need to have the company ensure that they are not providing rebates that do not address an increase in efficiency if they're funding equipment rebates. The second is related to new construction rebates for envelope measures, as well as other efficiency measures. Was not, at all convinced by the company in hearing that they have any legitimate means to confirm that they are actually funding measures that are above building code in jurisdictions. So that would be the second kind of most acute concern I have with DSM. So curious to hear from you, Commissioner Plant, but for me, I think the two kind of minimum conditions that I'm interested in on the DSM are with regard to gas-fired equipment, ensuring that the company has a means to ensure they're not, that they are requiring an efficiency increase in that equipment. And the second is with regard to envelope measures, especially for new construction, that they have a legitimate means to ensure that they are only incentivizing measures that exceed local building codes. So with those two concerns, be interested to hear your thoughts on DSM.
Can I just ask for a clarification before we turn it over to Commissioner Plant? So assume the commission imposes those two conditions. We don't want this budget to be used to fund like for like replacement, and would disallow or ask that it not be used for that. And two, it doesn't improve measures above building code. It only improves measures above building codes. Do you have a recommendation on the budget? Would you just approve the settlement agreement budget with those two conditions imposed?
I think that's a potential avenue. I'd be interested to hear from Commissioner Plant. I don't think we have an actual quantification, but I had really significant concerns based on the company's responses in the hearing that they have any kind of legitimate means right now where they're doing so. So I don't have a number to put to it, but my gut is we could have a significant amount of current budget going to those two concerns. So I don't have a number I can put to it. I would anticipate that there would be a significant under expenditure of the budget with those restrictions. But I think the restrictions are very legitimate, making sure essentially this money is actually going to what we think it is doing, which is reducing greenhouse gas emissions. If we're just giving people money for doing things they were going to do or had to do anyway, there is no legitimate actual outcome to the expenditure of that money. There's a true up mechanism here, or there should be a true up mechanism here. So even if the budget is a little too big in the first year, they don't end up spending that will kind of work itself out in a rider in the years to come. But I think it's hard to come upon a number because I don't think the company has, nor was offering in the hearing, a firm understanding of what percent of the DSM of these flavors would be subject to those restrictions.
All right. So we could leave the much higher budget, but with the understanding that a lot of it might not be spent if we.
It's a possibility. Yeah. Be interested to hear
right.
Commissioner Plant's take on the DSM, as well as once we get to the other areas of the budget. And then I think we can talk about how this is kind of apportioned. I think I have an expectation they would not spend it all,
Okay.
certainly, but to what extent we make that a requirement versus it works itself out in a true up, I think we can understand as we get to each of the sections.
I now understand where you're coming from. Commissioner Plant.
Yeah, I like that the clarifications that you made. I can just give you sort of a sense of where I was heading, which was similar, although on the furnace incentives, at least, I was thinking about it in terms of furnace incentives, and I think the new standards have gone into effect. So I think that that the expectation would be that there's an increase, obviously, in efficiency. But I think that, clarifying that is a good clarification to make. I was thinking similarly around where I was gonna propose was the settlement budget on DSM, but divided based on the sweep percentages. So not the amounts, because I think that, clearly we had identified we did not want to go over the cap amount, and sweeps budget did, but by percentage, which comes out to somewhere around 50%, a little bit different than 50%, but pretty close to 50% for BEE. And then on the DSM side, I was going to say, in looking at their DSM program for 26-27, the residential program has an MTRC cost effectiveness of 1.85. So I was going to say the residential program would qualify, as well as the income qualified weatherization programs that they have in their budget as well, which I think that both the sweep and the settlement talked about a minimum of 20% of the budget going to low or income qualified weatherization programs. So I would echo that within the budget that I would put forward. So again, take the see what the numbers were, 8.8 million that was in the settlement, divided according to the percentages, which comes out, it's close to 50%. I can give you the actual numbers, but it's, about 50% for BE, 50% for DSM, and then limit that DSM with, I think your caveats there, Commissioner Gilman, but then also just limit it to the residential programs. So they've got residential retrofit, moderate income weatherization, and residential new construction under their residential program, plus the income qualified weatherization programs.
All right. Well, I love that. So it sounds like there's a 3-0 vote to limit the DSM and forbid it from funding like-for-like replacements or for funding measures above if it's not above building codes. And then why don't we hold the budget conversation in abeyance till we go through the BE issues, but I'm supportive of what Commissioner Plant said, which was 50-50 allocation with maybe 20% going to IQ weatherization. But Commissioner Gilman, thoughts on Commissioner Plant's comments, anywhere you want to go. And Commissioner Plant, did you want to add something?
Yeah, just a clarification. So I was, and I don't know if your vote included this, but I was limiting it to the residential programs plus the income qualified weatherization programs, which residential programs came out to a 1.85 MTRC in their program plus the income qualified.
All right. So there's a third limitation or condition on the DSM spending, which is limiting it to residential programs. And even then, 20% would be on IQ.
And Commissioner
Okay.
Plant, the rationale for limiting to residential programming is based on the MTRC outcomes and ranking.
Yeah, I mean, if you look at the residential, like I said, that's 1.85 MTRC. The non-residential was 1.15. And then the income qualified weatherization is 1.21. So I was leaving out the non-residential just because non-residential new construction was under 1, and the non-residential retrofit was just 1.18. So it's pretty low in terms of payback, but the residential was quite high. The residential retrofit was 1.92, and the residential new construction was 1.86. So I thought that those being pretty high MTRC numbers would be a good place to sort of focus the investment.
Understood. Yeah, I think we all understood here. We're talking about significantly more limited funding than we did for some other clean heat plans. So you're just talking about focusing on the most cost-effective kind of areas of that, which I'm supportive of. And I'm also supportive of Commissioner plans. I think for the gas-fired equipment we have, essentially that the company would have to ensure it's not funding like for like, but also as Commissioner Plant added, that the equipment would have to exceed any state or federal minimums that would need to be installed anyway. I think that is implied, but seems worth saying. You're
Going
on
to
mute.
go to the next issue, Mr. Mendelson will come back and finalize the budget vote after we get a little further.
Okay. Now, with respect to beneficial electrification, Black Hills raises three arguments as to why BE is not applicable to them, that Colorado statute does not require them to, that it violates the takings clause, and it is not cost effective. Nonetheless, it proposes the Rocky Ford pilot, where BHCG, the Colorado Gas Company, will be credited for any gas, DSM, and BE emission reductions. The CHP funded portion of the pilot consists of administrative, marketing, and tracking and evaluation costs. Notably, it excludes any direct incentives, which are expected to come from the EPA via the IRA Act. Sweep argued that the company erroneously included the full cost of electrification upgrades for all customers rather than the incremental cost of the upgrade or provide an incentive. Additionally, Sweep disagrees with the inclusion of electric panel upgrade costs for all customers and the electric grid emissions factors used by BH. Sweep also claims the company's analysis excludes gas infrastructure and system operation costs. Sweep developed a bottom-up budget based on $2,000 per heat pump incentives for market rate customers and full cost for IQ customers that produces 37% more GHG emission reductions than the settlement. But Black Hills replies that its approach represents commonplace program design methodology. With respect to the issue of cost effectiveness, in its first order, C-250091, the Commission found we are unconvinced by Black Hills analysis and find its limitation to considering the emission reductions only during the 3-year life of the plan to be an unreasonable modeling constraint. As pointed out by Sweep, heat pumps have emission reduction benefits for the life of the technology long past 2027. Further, the Black Hills analysis, which used outdated assumptions and applied the full cost of upgrades, results in an unreasonably high cost estimate for BE. Notably, the recommended decision does not dispute that BE and DSM are lower cost resources. The recommended decision also does not contradict any of Sweep's analysis. The Commission also rejected the company's arguments related to Colorado statute and the takings clause. But the main issue before you now is, does the Commission require Black Hills to implement BE beyond Rocky Ford as it did in its initial decision? And what BE budget does the Commission wish to set for 2026 and 2027? And then does the Commission approve or still require the Rocky Ford pilot separately?
Commissioner Gilman, you want to get us started?
Yeah, sure. I think it's probably worthwhile from our previous deliberations to reiterate. I certainly found Sweep's analysis more reliable and compelling than the company's analysis, especially with regard to some of the modeling inputs and concerns that Mr. Mendelson covered, which I continue to share. But Commissioner Plant, maybe I'll go to you. It sounded like, or I don't, I feel like I can pass to you. It sounded like you had some thoughts or impressions on the budget and a view of how that should go. So happy to hear you out on your thoughts there.
Commissioner Plant?
Yeah, I mean, I agree with you in terms of the sweep analysis, particularly as it relates to the BE. And that was one of the reasons that what I was proposing was take the settlement DSM budget and apply the sweep percentages dividing it between BE and DSM. So that would be 4,338,462 for the BE and 4,461,538 for the DSM. And that would come out to that 8.8 million number that was in the settlement.
Okay. Commissioner Goman, you ready to vote on that proposal?
Yeah, I think that's reasonable. I think we have sufficient basis in this record to determine that BE is cost effective based on SWEEP's more reliable analysis of that. So I think you've provided a reasonable way to accommodate that and help the commission try to come to a clean heat plan or a modification of the clean heat plan that best balances what the most cost-effective resources within the cost cap look to be, so that we can help try to make that progress. So I agree with your proposal there.
And any other guidance, conditions, or direction you want to apply? Or you're fine with just what we discussed about?
I guess, Commissioner Plant, given that clearly the company has not put forth any kind of vision for how BE program or rebates would work, at least that we've endorsed here, would your proposal include just utilizing kind of SWEEP's proposed rebates, or any other thoughts on the structure within the $4 million budget there?
Yeah, thanks. I mean, I would base the assumptions on the sweep incentive levels. I think that those were reasonable. I think, if we wanted to include additional language on this, I'd say that, they should budget 10% to customer outreach, including at least 4 bill insert advertising opportunities to make sure that the actual program or the details of the program are getting out to the customers in an effective way.
Anything else you'd add, Commissioner Plant?
Not that I can think of, no.
All right. Mr. Mendelson, any further conversation on that?
I'm not sure if I heard a vote on the first prompt, which is, does the commission require Black Hills to implement BE beyond the Rocky Ford community?
I think the answer to that was a 3-0 vote. It does, and that it's going to be a $4 million budget.
All right. Just want to be perfectly clear there.
Or, as specified by Commissioner Plant. Commissioner Gilman, you want to say that different?
Yeah, I would say with 4 million and change, and based on this record, those programs would be structured largely off of the sweep proposed incentive levels, as that's really what we have in this record to go on for what that looks like for the customer facing piece.
Alrighty, thank you. And the final prompt was, does the commission approve or require the Rocky Ford pilot to continue? Do you find that any separation of BE dollars is necessary within Rocky Ford?
Yeah, for me, I'd probably leave the Rocky Ford pilot alone at the levels the company and the parties wanted. But anywhere you want to go, and I'm learning my lesson, Commissioner Plant. Why don't you go first?
Yeah, I mean, I'm not sure, in your description of the Rocky Ford pilot, you talked about the IRA incentives and the EPA incentives, and I don't know how, if this is a 23 filing, so I'm not sure how applicable, any of that is. It's a $80,000, basically a marketing program from the gas company. I don't see a problem with it. Certainly there's going to be additional incentives under our proposal for BE that would include Rocky Ford. I don't see a problem with including it. I just don't know how applicable it necessarily is at this juncture.
Commissioner Gilman?
Yeah, I don't disagree. I think I certainly came to appreciate in the hearing that really the proposal was essentially just for some outreach and no actual incentives. Since incentives, under this discussion would kind of layer over the entire Black Hills gas territory. Yeah, I agree. I mean, I think having some tracking and understanding of the results and the programming is a necessary piece of this, but the applicable area would be larger now. So perhaps it's looking at, you know, I think you would take essentially that budget and utilize that in part for the marketing and reporting and analysis across the entire program rather than just in that one specific area. Seems reasonable to me, as it will be important to get reporting and results out of this first effort.
Anything you'd add, Commissioner Plant?
No.
Does that give you what you need, Mr. Mendelson, to write an order?
It does, yeah. Thank you very much. All right, so the next issue is on the electrification study. Sweep suggests the electrification study is a waste of ratepayer money that simply kicks the can down the road. It contends that study places the company in charge, requires no party consensus, and would not resolve fundamental disagreements on legal and policy considerations. Instead, the commission should redirect the $300,000 budget to an expanded BE pilot program. Yep. So I'll leave it there. Does the commission wish to approve the electrification study as proposed in the second settlement, including $300,000 study cost?
Commissioner Plant.
Yeah, I'd be interested in hearing what you two think about this. And I kind of went back and forth on it. The Black Hills brings up the, unique nature of their service territory and the number of electric utilities that are crossing it. And, it might be worthwhile to look at how their program overlays with the electric utility programs. I also take sort of Sweep's observations that there's a limited amount of information that we would get from this. If we did do it, I would say that we would want to include, executable tables of all assumptions that are used in determining whatever their outcome is, just because I think we have a clear indication from the company that they're opposed to electrification. And if they're conducting the study, I think we'd want to just be able to see the numbers and be able to, use them as we might need to. So anyway, I kind of was back and forth on this, but I'd love to hear what your observations are.
Commissioner Gelman.
Yeah, I mean, I share a lot of the concerns that Sweep indicated with the study. I also think that we already have evidence in this record indicating the cost effectiveness of BE, so this may just be ground that is unnecessary to tread again, and in a way with pretty limited party oversight. And frankly, a fairly unclear scope of work that I'm not convinced was designed to address the major challenges that Black Hills even identified with electrification. So, as it was proposed, it certainly looked of limited use. If this money should be repurposed, around analysis or reporting on the BE efforts, that's probably another question, but I don't see particular use in the study as it was provided. So probably simplest to just exclude it, but interested to hear your thoughts.
Well, it would result in a commission decision that spent less than what the settlement proposed. So maybe that's not so bad. I'm fine with not doing the study, Commissioner Plant.
Yeah, I'm fine as well. And I would just note that the AMLD and the renewable natural gas were also not a part of our budget. That's about a $3 million reduction in the settlement budget from there, including, and then plus the electrification. So. I think we're
Um,
providing sufficient savings.
Let's keep going down in the order. Does that give you what you need on the study, Mr. Mendelson?
Yes, it does. All right, so the next item is third-party administration. SWEEP recommends the commission order Black Hills to use a third-party administrator to implement the Clean Heat Plan's PE programs, arguing this step is necessary to ensure successful implementation. Specifically, SWEEP recommends the commission require BH to develop a draft RFP and then take comments from the stakeholders in this proceeding with a goal to file a draft RFP with the commission 90 days after a final order in this proceeding. Then the commission should take comments on the RFP and either approve or modify it as part of this proceeding. Black Hills and other parties did not meaningfully respond to SWEEP's suggestion, but in the commission's order in C250091 regarding the first settlement, the commission did take this up and did reject the third-party administrator for now, saying there was not a sufficient record to rule on it. Nonetheless, there was a lot of discussion about the potential to use this this mechanism. So we bring it here back for your consideration.
Commissioner Plant, thoughts?
Yeah, I mean, I share the concern that I don't think we're going to get, good administration of this program without a third-party administrator. I'm not sure what our pathway forward is, and would be interested in hearing your guys' thoughts on that.
Commissioner Gilman?
Yeah, I think we provide this first opportunity to the company to see how they proceed and how they perform under this. And I don't know if we have an exact apparatus around reporting, Mr. Mendelson, but ideally we'll be able to understand as this proceeds with some regular reporting similar to DSM, how the company is performing. I will add that I think the company is welcome to use a third-party administrator and include the cost of such in its budget, so long as that's a reasonable percentage of the budget, if they determine that's the best way for them to provide these services. But I think it would be premature, since they have not even had a first effort at this, to determine that that is the only way to provide these services. So I would stay the course now, but certainly express that I think I, for one, would be open to, if the company determines that is the better way for them to provide these incentives, that they could do so.
All right. Would you have any more detail on what reporting you'd like to request, Commissioner Gilman?
No, I was probably going to ask Mr. Mendelson. I mean, I think we'd want to look at something at least similar to what reporting goes on in DSM, so that we can understand on a reasonable, interim basis how things are proceeding under the programs. But Mr. Mendelson, I don't know if you had an actual decision item around this, but just feel like that's probably an important part to understand moving forward how things are going.
We could certainly mock up something for your TBC review to show, dollars budgeted and spent and measures proposed and actually implemented, things of that nature that would help comprehend their success in implementing the program.
Ms. Dundas?
Thanks, Chair. So I'll just remind the commissioners that the clean heat rules do have Rule 4733, which is interim clean heat plan reporting, which requires by March 31st in all calendar years in which an application is not submitted, that the utility report on a number of things, but one of those enumerated list is the amount spent on each resource relative to the amount budgeted, amount spent on IQ customers, programming, and then the commensurate greenhouse gas emissions. So it sounds like the reporting Commissioner Gilman is considering is already contemplated by Rule 4733, and maybe the discussion is just what the right deadline is, since March 31st is obviously around the corner. Maybe it's kind of waiving that deadline in this rule and coming up with a date that would be appropriate for this plan, cognizant of the next plan coming in next year.
Commissioner Gilman, any further thoughts?
Yeah, I think that's reasonable. Obviously, March 31st is not going to net us a lot of useful information in this circumstance. So perhaps we move like 6 months out from our decision here and get an update just given the timing of how this falls in this year in terms of a waiver of that rule requirement for 2026. So we can get some timely update of how it's going, but be cognizant of the timing in which this is happening in this year. I don't know, Ms. Dundas, does that sound reasonable for
The
2026?
timing of this proceeding sounds like good cause to at least waive or modify that deadline to, I guess, 6 months from the mail date of the decision coming out of this deliberations, if that is a vote for that proposal from Commissioner Goman.
All right, does that give you what you need, Mr.
I think you
Middles-
need to vote on that waiver
Commissioner
and change
Plant?
of that deadline.
Yeah, I would agree with that.
Commissioner Gilman?
Yes.
I support that too. Does that give you what you need, Mr. Mendelson?
It does. All right, so the next item is on the DI Community Outreach and Engagement Plan. We did not pick this up last deliberation. The second settlement places $50,000 into DI engagement and outreach. There was not a lot of opposition to that, but does the commission approve that amount of spending for outreach and engagement of the DI community?
Commissioner Plant?
Yes, I agree.
Commissioner Gilman?
I would also agree.
As do I.
All righty, the next issue, I'll take up both AMLD and RNG together. With respect to AMLD and RNG, both resources were originally approved in the commission's order modifying the first settlement, C250091. However, the commission's January deliberation of the second settlement rejected both resources. Commissioner Gilman argued AMLD investments are already required and that the cost effectiveness analysis in this record excludes the cost of replacing relevant pipe sections. With respect to RNG, the commission noted that the resource was generally very expensive and therefore not cost effective relative to other CHP options. At this juncture, advisors just want to confirm those decision points specific to AMLD and RNG made in the prior deliberation. Specifically, does the commission continue to reject CHP investment in AMLD and RNG at this time?
And for my own benefit, can you just tell me where the settlement agreement's coming down?
The settlement, sure, placed about $2 million in AMLD and $700,000 in RNG.
I don't know that I'd zero them out, but Commissioner Plant, where are you going with this?
Yeah, I'd agree with zeroing those two out. I think it was demonstrated that they weren't cost effective, in particular with a limited budget. I think we should be focusing more on the cost effective technologies.
Commissioner Gilman?
Yeah, I generally agree. Additionally, with respect to AMLD, there's a cost effectiveness requirement to be considered a clean heat resource, which I think, is somewhat difficult on this record to make that determination. I also think AMLD is largely required otherwise, and especially sticking it into a clean heat specific rider could just cause some customer confusion about the purpose and need for this investment anyway. And the RNG, while I'm hopeful that could be part of a future plan and additional progress toward clean heat efforts in the future, with such a limited plan at our first attempt, I'm not sure it makes sense to go with a significantly less cost-effective resource with such a limited budget.
I made just a footnote in there saying I wouldn't zero it out, but I don't have an alternative proposal. And share the concerns expressed by my colleagues, but 0 seems not ideal either. So, but I'm not going to try and change anybody's mind at this stage. So keep going, Mr. Mendelson.
Alrighty, so the next item is on cost recovery. The company proposed that all expenses incurred implementing the clean heat plan and customer collections will be accounted for in new regulatory asset accounts to track the specific costs and revenues associated with implementing its CHP. Staff initially recommended the commission deny Black Hill's proposal to create a new CHP rider and instead order the company to recover CHP costs through its existing DSMCA rider. Staff argued Black Hill's proposed rider mechanism essentially allows the company to recover the upfront maximum amount allowed by statute, irrespective of CHP program implementation. The settling parties, including staff, supported cost recovery through the new volumetric CHP rider. However, parties reserve the right to advocate for a combined CHP DSMCA rider in future proceedings. They also suggest rider rates will be set annually on a forecasted basis. An annual true-up of the rider amount to reflect actual incurred costs, an asymmetric carrying charge equal to the company's authorized WACC, such that the over-recovered balances earn a WACC, but under-recovered balances are trued up with no carrying charge. And D, a clarification that the rider can only recover costs associated with clean heat resources. The settlement also suggests the company will file a compliance advice letter within 30 days of a final commission decision to implement the CHP rider. So here the question before you is, should the commission adopt the CHP rider as proposed and modified through the settlement or in some other fashion? You're on mute.
Do you have a view, Commissioner Plan, or would you like a recommendation?
Yeah, I'd take a recommendation.
Mr. Mendelson.
All right. Advisors suggest accepting the cost recovery provisions of the second settlement. That seems to be a reasonable approach, and so still leaves open the opportunity to revise things in the future.
Commissioner Plant.
I agree.
Commissioner McGowan.
Yeah, I think that's reasonable. Thanks, Mr. Mendelson.
I agree as well.
All right, so then the final item is kind of like a catch-all for other decision points, assuming the CHP is going forward, which it is. For each DSM program, CEO suggested the commission require the following reporting for each DSM program: an explanation of how the expanded and incremental DSM funds augmented the company's gas DSM plan funds and subsequent approved gas DSM plans. This can be accomplished by consolidating reporting of DSM and CHP spending. CEO also proposed a cost allocation protocol whereby it would require Black Hills to recover all of its gas, DSM, AMLD, RNG, hydrogen, and thermal energy costs from the gas bills of gas-only customers, gas-only and combination customers, and require Black Hills to split cost recovery for BE rebates evenly between the gas and electric bills of combination customers. First question is, should the commission, I should also mention that the settlement proposes a 60-90-day process to propose new programs or make changes to existing programs or discontinue existing programs. Does the commission approve of that 60-90-day notice process? And here the advisors recommend yes to approve that process as proposed.
Makes sense to me, Commissioner Plant.
I agree.
Commissioner Gellman.
I also agree.
That's do I.
Alrighty. The next item is to whether the commission should order consolidated DSM and CHP reporting. Here, advisors recommend yes to consolidate reporting as so we can understand the interactive and total effects of the CHP and DSM programming.
I agree with CEO there, Commissioner Plant.
I agree.
Commissioner Gilman.
I also agree.
The next item is, does the commission have any filing guidance for the next CHP? CEO had proposed requiring a 15% electrification portfolio. Here, advisors recommends consolidating the next CHP and DSM cases into a single filing in early 2027, requiring fully executable documents to the extent there are any analysis of electrification or other studies provided. And require the specified guardrails as were discussed earlier, and to include CEO's 15% BE portfolio.
Commissioner Plant, do you want to give us a recommendation?
Yes, that is our recommendation too.
Okay.
Yeah, to include all those items.
Commissioner Plant.
Yeah, I agree. One question, I think CEO's proposal for 15% BE was based on having no BE in the settlement. So is that still an applicable percentage to apply since we've significantly had a higher percentage here?
Well, I think their analysis is really for the next CHP. So what CEO was suggesting was to evaluate up to a 15% electrification to understand the emissions impacts.
Okay, I understand. Yeah, I agree.
Commissioner Gilman.
I also agree.
As do I.
All right. One more quick item is, does the commission agree with CEO's cost allocation proposal? I just mentioned that that certain items would be split evenly, including BE rebates, would be split evenly between gas and electric combination customers.
Shouldn't we decide that in the future? Do you have a recommendation?
We're recommending, yes, that seems reasonable at this juncture, but it was not thoroughly evaluated to be fully transparent.
Do you have a strong thought, Commissioner Plant?
Oh, I mean, I'm fine with that recommendation. Yeah, and I don't know if we did the thermal energy networks, Mr. Mendelson. Did we?
Well, did we not? Did we miss that? My apologies. I think it was picked up in the last deliberation, but if you want to, we can go over it again. The company had proposed a thermal pilot program of $380,000. It was supported by the settlement, and so the commission could vote on that now.
Commissioner,
I think Commissioner Gilman hadn't voted on the last one yet. I was just asking, so I didn't remember.
Commissioner Gilman.
That was all true. Yeah, I agree with the cost allocation, and Chairman, yeah, I feel like especially with the others at the imposition of the rider, we had to determine how it was allocated, although certainly could be reconsidered in the future.
I don't disagree. Does that give you what you need, Mr. Mendelson?
It does, yeah. And to go back to Commissioner Plant's, I believe the commission did approve the thermal pilot.
Okay, if we already voted on it, I was just
that's why I didn't bring it back forward.
I was just going to express my approval, but
yeah,
we already did that.
Same. I think we did approve it, and if not, I think that's an appropriate part of the budget.
I agree. Ms. Dundas, did you have another way in?
And just really quick, I think that was the completion of Mr. Mendelson's decision points. Is that right, Mr. Mendelson?
Yeah, that's correct.
Just on that last one, I heard that it'd be a consolidated DSM and CHP next filing in early 2027. I think we'll need to be more specific than that to avoid an additional filing for the decision. So again, that could be a year from the mail date of this decision or some other date, but I think we need a date in that decision.
Yeah, let's do a year from the mail date. And if advisors or counsel think something different, why don't you suggest it in a TBC process? Would that work for you, Commissioner Plant?
Yes.
Commissioner Gilman?
Yeah, I'm good with a year.
And why don't we do this as a TBC order? Does that give you what you need, Ms. Dundas, Mr. Mendelson?
Yeah,
Yes.
I just want to confirm with Mr. Mendelson, I didn't overstep there, right? Is a year from the mail date, except what you had in mind?
Yeah.
Okay. Then yeah, I have everything I need. Thank you.
Mr. Mendelson?
That's all for today.
Well, I just want to thank you, Mr. Mendelson, for a really incisive way to get us through the decision points. Thought that was very well done, and Mr. Eden as well. These were really complicated issues that you got in front of us in a coherent way. So thank you, Commissioner Plant. Final thoughts,
No, nothing much to add. Thanks.
Commissioner Gilman.
Nothing additional. Thanks.
Thanks. We're adjourned. See you next time.